Hello friends, in the series on the income tax cases, today we will discuss a very important case of SHAILESH versus Income Tax Officer and others. This case has been reported in 456 ITR at page number 374 and the matter has been decided by Honorable Bombay High Court and the date of the judgment is 23rd September 2022. As all we know that it is a settled law that if any notice is issued to any assessee who is no more in this world, so that notice issued by the department is non-est. That notice do not have any value. But whenever the notice is issued to a dead person and the notice is received by the legal heirs of the assessee, it is the plea of the department that we were not aware at the time of the issue of the notice whether the assessee was alive or not, so the assessment proceedings should go on. But it is the considered view of the courts that if after the issue of the notice, the assessee legal heirs inform the department that the assessee is no more and the assessee was dead before the issue of the notice, then in that case the notice will be invalid. In these type of situation, the right course available to the department after getting the intimation about the death of the assessee from the legal heirs of the assessee is that the department should drop the proceedings initiated in the name of the dead person and should again initiate the proceeding in the name of the legal heirs. But the problem for the department is that the department is always late and the department issues the notice only at the fag end when the limitation period is going to expire. So in that cases, the assessee gets the benefit of the lethargic nature of the department. In this case, the notice was issued to the dead person in the name of the dead person. The notice was received by the legal heirs. The legal heirs, after receiving the notice, approached to the income tax department by showing the death certificate of the assessee that the assessee was no more before the issue of the notice. Hence, the notice is invalid. But the assessing officer, in spite of dropping the proceedings and reinitiating the proceedings against the legal heirs, continued with the assessment. And when the assessment was done under section 147, the assessee approached the Honorable Bombay High Court and said that this assessment proceedings are null and void because these have been done in the name of an assessee who is no more in this world, and the department was duly informed after the receipt of the notice from the income tax officer that the assessee is no more. But the Bombay High Court did not entertain the basic idea of the department that at the time of the issue of the notice or before the issue of the notice, the department was not aware about the death of the person. So in those cases, the right approach on the part of the AO was that when the intimation was received from the assessee's legal heirs, that he should have dropped that proceedings and reinitiated the proceedings against the legal heirs. But the department has not done so. So in these circumstances, the notice, the demand notice, the assessment order which have been passed are null and void. They do not have any value in the eyes of the law and the whole assessment is quashed by the Bombay High Court. Friends, from the analysis of this decision, it is clear message for the assessees and the professionals that whenever there is any death of any assessee, then first of all the fiscal department should be informed that the assessee is no more and that should be supported by the death certificate of the assessee. If the assessee will do this primary work of informing the department, then there are very good chances that any proceedings which are initiated after the death of the assessee will not be valid in the name of the assessee. Although it is very clear that the department can initiate the proceedings against the legal heirs and can collect the tax from them up to the amount which they have inherited from the dead person. At the end of this video, once again, I am repeating the name of the case. The name of the case is SHAILESH Shah versus Income Tax Officer and others. And this case has been reported in 456 ITR at page number 374. The matter has been decided by Bombay High Court and the date of the judgment is 23rd September 2022. Thank you, friends.